Good afternoon, everyone. You're very welcome to Landed's webinar this afternoon, which is on GDPR and what it means for your business when hiring. My name is Michael Green. I am the head of finance at Landed and a certified GDPR practitioner, so I take on the role as data protection officer for Landed. So what we're going to cover on today's webinar, I'll just do a quick introduction to Landed and who we are. We'll run through what is GDPR and how it differs from the current legislation. We'll touch on the concept of accountability and data governance and how they're affected by GDPR. We will go into consent and privacy notices and cookie policies in a wee bit more detail. Then I'll outline some of the breach reporting requirements under the new legislation and some of the updated sanctions. Finally, we'll do a quick summary and then a couple of slides in on how Landed can help you as a recruiter stay in line with the new legislation when it comes in next year. Okay, so Landed is a recruitment marketing software company. What we do is we transform the way companies market their job opportunities and how they collect and screen applicant data to enable them to make the best hiring decisions. We've got an all-in-one solution which gives businesses the ability to create, publish, track, and analyze all of your recruitment marketing campaigns and activities from one integrated dashboard. We've got a team of experienced online recruiters who are on hand, on demand to help and provide expert advice when it comes to all of your digital recruitment needs. Okay, so what is GDPR? GDPR is the new General Data Protection Regulation, which will come into effect in the UK on the 25th of May 2018. The Data Protection Act, which is in at the minute, was a directive, whereas the GDPR is a regulation, which means that all member states must implement it. GDPR applies to data controllers and to data processors, and the definitions within GDPR are broadly the same as what they are under the Data Protection Act, but there are a few new areas that you should make yourself aware of. If you're currently subject to the Data Protection Act in any of your activities, then it's extremely likely that you'll also be subject to GDPR in those same areas. The regulation places specific legal obligations on data processors, for example. So you're required to maintain records of personal data and processing activities. You will also, as a data processor, have a significantly more legal liability if you're responsible for a breach. Data controllers will now have additional responsibilities to ensure that their processors comply with the contracts that they have in place. So from a controller point of view, if you're hiring an outside company to process any of your data, it's important that you look at the contracts that you have at the minute and ensure that they are in line with the new regulation as it's coming forward. The regulation applies to personal data, which is any data that can identify a living individual. It does not apply to business data. For example, accounting information would not be covered. The essence of the legislation is to safeguard the rights of EU citizens and to put control back in the hands of the data subject, forcing businesses to take a proactive approach to data protection. The UK government has also confirmed now that the legislation will not be affected by the decision to leave the EU. It has already been passed in EU law, and May 2018 is the deadline for implementation by member states. So it actually came in 2016, and the law was passed, and then there was a 2-year time period for implementation. It applies to the processing of personal data of EU citizens regardless of whether the organisation is located within the EU or not. So if you're processing data in relation to any living individual within the EU, then you'll be subject to the new regulations under the GDPR. Okay, so if we look at what's new under GDPR, there's 2 key areas within GDPR: accountability and data governance. Controllers and processors are required to implement the regulation and demonstrate that they do so. Demonstrate is a very key point here. Businesses must put in place systems to ensure that they can prove compliance. This requires management buy-in, a top-down approach, and it also requires that adequate processes are in place to monitor and maintain your compliance. The definition of personal data has remained largely the same, but it has been expanded under GDPR to include data such as online identifiers, so things like an IP address, if you're storing that through any of the tracking software that you might use, or cookies if you're placing cookies onto an applicant's device whenever they log in to apply for a job through a specific portal. These types of online identifiers are now classed as personal data, and they now require additional safeguards under GDPR. Sensitive personal data classed as special categories of data such as genetic data or biometric data or data concerning health requires explicit consent for processing data. So if you're asking questions within an application in relation to collecting health information, that would now need to be treated appropriately, and you would have to receive explicit consent for processing that data and be able to demonstrate that you've actually received the consent to hold that data or process that data. GDPR also applies to both automated personal data and manual filing systems. So if you have filing cabinets which are full of candidate records or employee personnel files, they're also covered under the legislation. So it's not just in relation to online data. Manual filing systems are also covered by the legislation as they are currently under the Data Protection Act. Data subjects now have additional rights under GDPR in respect of how their data is handled, and specifically the right to port their data and the right to be forgotten. An example of the porting of data would be if I wanted to move my dental records from one dentist to another, you can basically ask for that data to be transferred or to be ported, and employees and applicants would also have the same right to have their data transferred from one employer to another if they so wished. Consent will be harder to obtain and harder to rely on, so companies now need to put tracking mechanisms in place to ensure that they can gather consent efficiently and maintain it. We'll go into that in a wee bit more detail under the consent heading. A special emphasis under GDPR has been placed on transparency, so companies now need to update their privacy statements to be concise, clear and unambiguous. They should be standardized and auditable. So you should ensure that you keep a log of changes to your privacy statements and put processes in place to track the policies that were in place when an individual provided you with their data. Profiling is also specifically mentioned in GDPR, and any automated decision making must be notified to an individual. Data subjects then have the right to request human intervention. So that could be extremely important where you're putting any automated decision making in place around applicant tracking, so that you need to make the individuals aware that that process is in place, and if they so wish, then they would need to have the ability to request human intervention to take a look at the process that was in place and that was carried out and ensure that it was adequate. The penalties for a breach of the GDPR are extremely onerous, and they have the potential to cripple any business. The top level fines are now up to 20 million euros or 4% of global annual turnover. The current Data Protection Act and the ICO's current powers give them the ability to levy fines up to £500,000. So increasing from 500,000 to 20 million euros is a major step. And the ICO have actually never issued a £500,000 penalty. I think 400,000 was their highest, but that's not to say that they won't under the new legislation start to increase those fines into the millions. Data transfers to non-EU countries are also specifically mentioned in GDPR, and the authorities have issued a white list of countries which are deemed to have adequate data protection controls. It's important to note that the US is actually not on that list, but there is the new EU-US Privacy Shield, which replaces the old Safe Harbor. So if you're dealing with any processors in relation to your recruitment activities or your marketing activities, then you would need to ensure that those processors are self-certified under the Privacy Shield. and that just gives you an added layer of comfort that their processes are broadly in line with the GDPR. So Article 5 sets out the principles in relation to processing personal data, and it legislates for the concept of accountability. And what it says is that the controller shall be responsible for and able to demonstrate compliance with accountability. There's 6 key areas here. Number 1 is that data is processed lawfully, fairly, and in a transparent manner, that it's collected for specified, explicit, and legitimate purposes, that the data is adequate, relevant, and limited to what is necessary. So that comes back to the minimization of data, which is emphasized under GDPR. So that you're only holding data that you actually need. Data must be accurate and, where necessary, kept up to date. So you need to think about the processes that you have in terms of keeping any data that you hold up to date and accurate, and given the ability to amend data if it changes. It should only be retained for as long as necessary. Again, it's data minimization, so you're not holding data for longer than you absolutely need to. And that it should be processed in an appropriate manner to maintain security. So again, that's around making sure that your security policies are up to date, and that any data that you're transferring within an organization or outside an organization is encrypted where that's possible. This statement in relation to accountability really raises the bar across the board, and process will be key to demonstrating accountability. Your privacy statements must provide more detailed information and be concise and easy to understand. Your consent must be unambiguous. Profiling, as I mentioned previously, will be subject to greater focus, and now mandatory breach notifications have also been introduced. The bottom line here is that businesses need to shift their focus to a proactive approach to data protection, and it should be now data protection by design and by default. Data governance is closely tied to accountability, and organizations need to put good governance in place. Specifically required within GDPR are that all public bodies must appoint a data protection officer, as do organizations who are processing large amounts of sensitive personal data, and organizations whose core activities is a systematic monitoring of data subjects. This has resulted in a shortage of data protection officers, and as such, you may wish to consider which staff within your organization may be suitable for taking on a role, and provide them with adequate training in relation to data protection and GDPR. As I mentioned, process is key, and identifying and carrying out data protection impact assessments and establishing data protection by design and default is the way forward. You need to think about how you can meaningfully keep records and how to build a single view of all interactions with a data subject. Where there's a high risk to data subjects' rights, GDPR requires mandatory data protection impact assessments to be carried out, and the ICO would also come in the case of a data breach and look to see those data protection impact assessments and see that adequate process was put in place where risks have been identified. And you should consider whether your recruitment marketing activities are designed with the data subject's rights in mind. That's the key under GDPR, is that the data subject rights should be put at the forefront of all processing activities. Article 4 deals with consent. In general, you'll have to have a data subject's consent to process their data. While there's specific circumstances where consent is not strictly necessary, these would generally revolve around legal requirements, such as compliance with another law or to protect the data subject's rights. The conditions for consent are outlined here on the slide, and that must be freely given, specific, informed, and unambiguous. Consent is presumed not to be freely given if it does not allow separate consent to be given to different personal data processing operations. The controller must be able to demonstrate the data subject has consented to processing, with demonstrate being the important word there. And data subjects also have the right to withdraw consent at any time. So basically, your consent should cover all of your processing activities carried out for the same purposes. And if you're processing for multiple purposes, then you need to get consent for each of those different purposes and provide an opt-out mechanism to the individuals. Privacy notices are also highlighted within the new regulation, and they're important, and they're an important and necessary way of being transparent and telling data subjects what you're doing with their information. So you should have a clear privacy notice and make people aware of it on your careers website or on other recruitment marketing campaigns, such as landing pages. It should tell people what information is being collected, who's collecting it, and how it's being collected, why it's being collected, and how it will be used, and who it will be shared with. You can find more information on the ICO website, and there's very good guidance in relation to what you should include and should not include within a privacy notice. So you can find more information on the website there. Okay. As I mentioned before, cookies is another thing that you need to be aware of if you're doing online recruitment marketing. There's a few issues around cookies, and the regulation states that if accepting cookies is as easy as clicking a link on a landing page, then they should be able to withdraw the consent in the same manner. So it should be just as easy to withdraw consent to accept a cookie as it is to give your consent as well. Once fair notice has been given, continuing to enter a site in most circumstances can be valid consent via an affirmative action. So by that I mean if you put your cookie policy notice on your website or on your career site, and you tell the applicant or the data subject that by continuing to browse on your website that they're providing you with approval, then that would be deemed to be an affirmative action. Many businesses are now updating their cookie policies. An example here is the EasyJet website, which they've actually taken a stance where they'll not allow you onto their site without first accepting their cookie policy. And other similar companies have similar notices as well, which require a positive affirmation before you can actually access any of the information on their website. So if we just look at the breach reporting requirements under GDPR and the sanctions that they can put in place. In a world of increasing cyber attacks, it's inevitable that breaches will or may happen. The mere fact that a breach has occurred does not necessarily mean that companies will be severely punished. The ICO will look at how companies have handled a breach in the first instance. One of the requirements is that a breach must be reported within 72 hours, and that's a new requirement under GDPR. So it's a self-certification type method. Where the second thing that they would look at was were adequate processes in place to reduce the risk of infringement of data subjects' rights. So was the data that's been lost or breached, was it encrypted or pseudonymized? If that's the case, then obviously that would be favourable in the ICO's view. And where there was a risk identified, have the individuals been informed? So if a breach occurs and you identify there's a risk to an individual's rights, then the individuals themselves must be informed without undue delay. The penalties for failure to comply with GDPR, as I mentioned, are extremely onerous. And Article 83 states that the fines will be effective, proportionate, and dissuasive, and can be imposed in addition to or instead of corrective powers of the ICO. The corrective powers that they're talking about there would be like issuing warnings or reprimands or ordering companies to comply with data subject requests. As a small company, you do not want to be one of the first companies to be reprimanded by the ICO, as they likely make an example of early offenders. So it is important to take necessary steps now to ensure that you have adequate controls and processes in place to ensure you're compliant. As I mentioned previously, the fines are up to 20 million euros or 4% of global annual turnover. The other important thing to note is individuals also have the right to compensation. So as well as receiving a hefty fine from the ICO if you're in breach of GDPR. The individuals whose data and whose rights have been breached can now also make a claim against the company. So that could also increase your liability. So just in summary, companies need to act now to ensure that they're prepared for the new regulation. So you should be taking steps to identify what data you currently hold, whether you have a lawful basis for processing that data, and whether your systems are adequate for ensuring that data is maintained in a compliant manner. Data protection by design is essential to ensuring that you're prepared. So this means looking at what systems are in place to handle data. How can these be modified to ensure that you have a full picture of all interactions with a data subject or an applicant? And do you have a single view of all those touch points? As mentioned previously, you must be able to prove how you have put measures in place that ensure the rights of data subjects are protected. Consent can be relied upon. However, you must ensure that data subjects have freely given this consent and have measures in place for the removal of that consent as well. Transparency is key, so you should update your privacy notices and cookie policies to ensure they're clear, concise, and accurately reflect how data is collected and used, and take steps now to ensure that all data processing from a recruitment marketing perspective is open and transparent. This new regulation can be an opportunity for your business. Applicants are more and more aware of their rights, and they will look to interact with businesses that take a proactive approach in respect of protecting their data and their information. So the final thing is the fines, as I mentioned previously, are a significant risk. So you should act now to ensure that that risk is mitigated. So the next couple of slides is just going to briefly outline how we here at Landed are helping companies bring the recruitment marketing processes and applicant tracking systems in line with GDPR. By bringing all of your organization's recruitment marketing and applicant tracking activities under one single dashboard, you'll have a central repository of data subjects information, which will make it much easier to maintain accurate and up-to-date data. If, for example, you're running email campaigns, job board adverts, or social media campaigns, all of the data coming back from those campaigns can then be collected in one place, and it's much easier to then respond to a data subject access request and to remove data from your systems when it's no longer appropriate or lawful to retain it. If you're working on multiple systems such as an email provider, a CRM, or a social media management platform, you'll find it very difficult to accurately maintain all of those databases, and you'll find it very difficult to remove data easily, and you'll also struggle to get a single applicant view which tracks all touch points with an individual. The Landed platform ensures you obtain permission from every applicant who engages with your job advert, including privacy notices, cookie pop-ups, and terms and conditions. So by having a set of standard templates, you can be sure that all of your recruitment marketing and campaigns have transparent notices in place. And when data subjects interact with your campaigns, you can tie this all back to the policy that you had in place at the time, which again goes back to ensuring that you have a full audit trail on consent. With a single applicant view, you can track every interaction with a data subject across all campaigns and channels. You can also monitor the consent status of each individual. So if you are collecting consent to reach out to an applicant via SMS or email or by telephone, you can capture that all within the platform and ensure that before you contact a candidate via a particular channel that you actually have consent to do so. And again, you can tie each element of consent back to the time of collection, the campaign that was used, and the policies in place at that time. So again, you're having that full audit trail to ensure that you're remaining compliant. So our Landed recruiters are a team of recruitment professionals, and they're on hand, on demand to assist with all aspects of campaign setup and management. This can include guidance and assistance to build digital recruitment campaigns and review results, or to help create your overall recruitment marketing strategy. We can also provide ongoing advice around ensuring compliance with GDPR. So from $4.99 per month, we can provide you with the tools to manage your entire recruitment marketing activities, including full online applicant tracking and screening. Dedicated support per month to ensure your campaigns are both effective and compliant, and most importantly, ensure you get the best hire for your company. In addition, we're offering a 90-day money-back guarantee, so you can try the system for 3 months. At the end of that period, if you don't wish to continue, we would offer a full refund. If anybody would like to book a free demo of Landed, you can go to our website, which is www.wearelanded.com, or you can email at info@wearelanded.com. Thank you for your time, and if anyone has any questions, I'll open them up and be happy to answer them.